John is in court to claim the court maximum of £5,000, owed on a loan he made to his former friend to help set up a new business. Defendant Stephen says there was no deadline attached to the loan, therefore he should not have to pay in one lump sum.
Number 2, payment. This is the important bit, right? This is the bit that matters. It's what you're doing here. This loan may be repaid in consecutive monthly instalments of principal only on the 28th day of each month commencing the month following the execution of this agreement. I need a moment. Until the lender provides a borrower with written notice of a demand and the balance and part thereof owing under the agreement will be paid within 28 days of such notice of demand. What on earth have you got against a comma?
They weren't in the templates.
Where? What templates?
Well, I can't remember the exact...
Well, thank goodness.
...website.
Please look at the second clause in that contract. It clearly says that after the date of this agreement, which is signed on the 5th day of June of 2015, the money's to come back in monthly instalments. Clearly says it. Easy peasy. What's missing?
The amount. The monthly amount.
Very good. In other words, a plain reading of that clause is very problematic. It clearly generates a legal agreement between the two of you, only it doesn't specify the monthly sums. That could be 5p. I could read it. I could read that as 5 pence. He could have 50 years to pay that back. Correct? Mistake. Yes?
Yes.
Here's your problem. It gets rather worse. You, as I understand it, took the view, not long after drawing this agreement up, that there was a problem with it. Correct? And that you were concerned that it was insufficiently precise. Am I right?
I suppose so.
Well, what you say in your claim is that there were 2 subsequent discussions that you had in order to amend the terms of the agreement with Stephen, right? You gave him the cash in 2015. And this is important. In July, you say in your claim that you contacted Stephen and you verbally asked for new terms, which you say he understood, that you said the money is to be returned within 3 years.
At the time,
yes,
I thought 3 years was reasonable.
I think you're right.
And
the difficulty you have, sir, is that you acknowledge that you, having looked at that, realised that the agreement didn't specify that it needed to come back within 3 years. So you sought to amend or vary this agreement by telephoning him and saying, here, Stephen, just so you know, you've got 3 years to pay it back. Is that correct? Did you have a telephone call of that kind?
I think it was face-to-face, Judge.
Fine. You accept that that was discussed with you?
Yes, Judge.
Did you accept the terms of that agreement?
Yes, I thought it was reasonable.
Except we've got a big problem. Clause 14 of the downloaded agreement. This agreement constitutes the entire agreement between the parties, and there are no further items or conditions, provisions, either oral or otherwise. The only signed agreement that you have, that you downloaded from, as Peter Kay would say, Tinternet, specifically legally precludes you from amending or varying this arrangement. In other words, it doesn't matter what you say afterwards, even if he accepted it, because the only extant legally enforceable contract you've got says all bets are off after this is signed.